Dear guest, glad to welcome you on our channel. It's the Center of Law Support, and today we will take under discussion the theme of effectiveness of justice. So, let's go. At the initial study stage, the authors mentioned that today's Russia is undergoing a stage of judicial reform. Reforms are permanent, society is evolving, and the judicial system is developing as well. Therefore, here the questions arises: what is the purpose of judicial reforms, their meaning and significance? The answer is to increase the justice effectiveness. However, the truth depends on the subject given it. It might be the legislator, the law enforcement, or other participants of the process. We are often talking about simplifying the order of activity and the form of legal proceedings. Reform cannot be the cause of every social process. It isn't a patch-like thing. The purpose of the ongoing procedural and judicial changes depends on the subject of legal activity in its broad sense. Ultimately, it's only the protection of persons whose subjective rights and interests protected by law are violated. Improving the effectiveness of justice is a follow-up to the latter category. Ms. Chechnya reasonably noted the problems of the civil procedural law is individual institutions. Judicial practice in civil cases is the second, after ensuring the rule of law in this category of court case. Main direction of civil procedural law, science development. One can start a rather lengthy but unfortunately scholastic discussion about the definition of effectiveness. In any case, it must be carried out, but this is not an end. Therefore, Russian legal scholars call the system being effective only if it guarantees the achievement of a result that was previously conceived as a goal and the solution of the task set by the system. Larin understood the effectiveness of legal proceeding as the quality of the activity and its productive nature. In many ways, every person understands whether justice is effective or not. It's worth asking and passerby, and many will answer positively or negatively, but they will express a judgment. The formula does not place the prevailing role in the context, but the real state of affairs when deciding to apply the judicial authority. However, the appeals more likely the task of civil litigation are fulfilled. One way or another, the implementation of measures to improve the quality of justice, improve legal proceedings, and its constant adaptation to the needs of the state and society, uh, an integral part of the ongoing democratic process in Russia. The above circumstances determine the purpose of this study, which consists in the development of mechanisms to assess the effectiveness of the courts in the consideration and resolution civil cases from the real goal achievement point of view, which is expressed in the restoration of violated subjective rights and the interests of individuals protected by law. Uh, Taking into account time, material, and other costs. The mechanism is of particular importance since it can be the basis of legislative activity in terms of modifying the procedural and judicial legislation and can be used by the law enforcer in the implementation of judicial direction. When we're deciding a particular petition application or performing one or another procedural action as well as determining the direction of the proceedings, the court may take into account the developed criteria so that the final judicial act is not only legal and reasonable, but also provides protection of interests that correlates its content subjective rights subjects of civil turnover. And now we can formulate the theses, which are as follows. Ensuring efficiency should be considered as one of the requirements for judicial acts. And then to evaluate the effectiveness of the key role is to achieve the task of civil proceedings. Questions of justice effectiveness, the research subject of Maniak, Prikhotchka, Skolorenko, Shekaran. However, one of the main works stays is works which written by Tsikhotsky. At the same time, in modern works, especially devoted to the problems of the judiciary, the questions of its effectiveness over the past 3 decades has not been devoted to a single independent chapter, not a single independent paragraph. In the context of a dynamically transforming civil turnover, the rule of the law society, there is an urgent need to rethink theoretical and applied approaches to justice efficiency. As Melnikov noted, the relevance of the scientific development of criteria for the effectiveness of the civil procedural legislation application is undisputable, which makes it possible to determine the effectiveness of judicial protection of rights and interests protected by law. Legal certainty as a scientific and practical category has never been an independent object of monographic and dissertation research, both in the field of legal theory and the field of civil procedural law. Its genesis, history of from education and essence. Certain aspects of legal certainty as a principle of law was studied by revolution scholars of the civil process by Pokrovsky, Vaiskovsky, Rizanovsky. In the Soviet period, public principles prevalated in the civil process. Priority was given to the principle of legal judicial acts as opposed to their stability and certainty. Therefore, issues of legal certainty will not be object of study. At the present stage of civil procedural law development, with the expansion of dispositive elements and the ratification of the conventions for the protection of human rights and fundamental freedoms, some scientific words have appeared that address some aspects of legal certainty. However, as applied only to certain blocks of civil process problem, they were to appeal judicial acts. International civil process, so some issues of ensuring legal certainty in Russian legislation arise in the publication of Vitruk, Sultanov, Tumanov, Yarkov. One of the cases, which was initiated by Troitsky District Court of Altai Territory and which is currently in the proceedings of the Avtozavodsk District Court of Taliati, has been under consideration for more than 8 months. Such a long period is not a remarkable record for Russian courts, although it exceeds the time limit established by the Article 154 of the Civil Procedural Code. Meanwhile, talking about procedural actions, the implementation of subjective right, and other procedural categories, we should not forget about the disputed property. Vehicle debt has been on street for almost a year and has been not used. Solving such conflict, the legislature seeks to introduce changes in the procedural legislation which are prospectively directed. Unfortunately, this is not always the case. Increasing the competitiveness of participants, or rather the discretion of the court, which will ensure the desired competitiveness, and this is the key to improving efficiency. Striving for formalism, it's forgotten that the proof burden rests on the parties due their Article 56 of the Code of Civil Procedure. If one of the participants disclosed all evidence, then submitted it to the court and took part in their investigation, and if the second party did not present any evidence for 8 months, the case can already be resolved due to Article 2 of the Code of Civil Procedure of Russian Federation. The resolution of the case lies in the evidence assessment in compliance with procedural law, but not in the court's attempt to establish objective truth. Despite the dynamic nature of the legal proceedings noted above, the current period is characterized by the ongoing reform of both the court system and the procedural legislation as a whole. The judicial community proposes some changes. So, a number of draft federal law on amendments to certain legislative acts subsequently introduced to the State Duma of Federal Assembly are formalized by resolution of the plenum of the Supreme Court. Many changes, of course, are associated with the optimization of civil proceedings aimed at simplifying the procedural form. In particular, Tirohan and Zahara wrote about this. Such a task, of course, has a right to exist. Moreover, new types of cancellation procedures appear in the in the current procedural legislation, which affect the number of cases considered. If these innovations, coupled with the task of civil litigation, the reform of partnership business relations, will contribute to the settlement of many disputes even before applying to the judicial authorities. However, simplification of the procedural form should not entail complication of the procedural for applying judicial protection. Often, to ensure the effectiveness of justice, it's enough to implement the norms of procedural law correctly, allowing subjects to seek consideration of a civil case as soon as possible. In this turn, the formalist approach not only leads to a delay in the time of applying the judicial authorities, but also jeopardizes the issuance of a lawful and just fulfilled. Judicial act due non-consolidation by administrative acts of information on facts and other reasons associated with temporary separation from the events that give rise to a conflict situation. Legal certainty as one of the regime elements implies stability. Stability is expressed in an identical approach to the application of procedural law. Res judicata should be a kind of code that holds the fusion of legislation of the particular application during the transforming of judicial system in procedural form. Meanwhile, practice showed that courts use the procedural rule that have already been established at this point rather heterogeneously, thereby creating new nuances of ensuring access to justice. Justice can and should be certain, however, any modernization will be accompanied by a decrease in the effectiveness of justice if the number of pending cases is reduced for reasons beyond the control of those who wish to seek judicial protection, which incidentally is required in many cases. Analytical calculations regarding the justice effectiveness will not be diminished if approach to understanding the justice category is used. So, if the latter is considered as the activity of the court, starting from the moment the petition is filed with the court until uh, the final X is used, which ends the proceedings. The essential link that does not allow the value of the efficiency index to reflect that real situation is missed. It should be noted that there is a coefficient indicated the number of cases for which proceedings have not begun. Meanwhile, is subjects really needed judicial protection or violating or contested subjective rights. Thus, legal uncertainty threatens the achievement of civil proceeding tasks, in particular the correct timely case consideration, which in fact the abstract formula for calculating the effectiveness of justice multiplies the quotient by a factor equal to 0. Uncertainty, in terms of ensuring the justice accessibility, it's observed in the following situations where real rights protection and disputed legitimacy was not possible. One of the court in Altai territory ruled leave the application without movement. Then it was pointed out that the attached printouts of the correspondence from the WhatsApp messenger were not properly executed, namely the protocol for inspecting the relevant pages at the notaries. It was not completed. The lawsuit did not indicate that the plaintiff in the court session would provide an opportunity to investigate the correspondence from mobile devices. In this case described, there is obviously a lack of effect of the res judicata principle in the procedural application. It's a potentially reasonable to talk about the refusal to exercise the right of judicial protection. Of course, the definition of legal uncertainty can be considered in various guises. However, the denial of justice can be understood as a situation in which the court does not consider the merits of the application without sufficient legal grounds. It can be argued that the restoration of the rule of law did not take place. Tryushnikov indicated that procedural action that indicate evidence and not according to their actual presentations are provided as a requirement for the statement of claims from. It's unlikely that non-admission of evidence is a formal basis for leaving the statement without motion, despite the mention of the term must be in Article 56 of Civil Procedure. Proof in itself is a right and not an obligation of persons participating in a case. The prerequisites for the right to sue and the conditions of implementation, which were formally fixed in Article 134, 135 of the Code of Civil Procedure, were fulfilled by the plaintiff. Procedural law does not fix the obligation to present properly certified copies of documents at the hearing. When making ruling, the judicial could indicate the need to submit certain documents to the court. The plaintiff had the opportunity to collect necessary information during the stage of preparing the case for trial, as well as court itself. Moreover, they had the opportunity to act passively. That court would have had grounds to refuse to satisfy the requirements, but not leave the application without motion. In addition, they evaluated the evidence which is allowed only on the trial stage. At the previous stage only, the subject of evidence is usually determined. Meanwhile, the court actually went beyond the resolution of those issues that are related specifically to the stage of initiating proceedings. Thus, the rules were ignored, but the court is entitled to request the evidence necessary for resolving the case only when it's prepared for the hearing. And when considering a claim on the merits, it's only entitled to invite the participants to submit new evidence. For judicial practice, the formal clarification remains valid. It's unacceptable to refuse to institute civil proceedings on the ground to improve and claim, missing the statute of limitations and other ground not provided by law. Simplicity consisting in the optimality and rationality of the action taken. Leaving the application without emotion, the judge did not reduce the load because it will be felt again, which one way or another will determine the decision to accept the application and prepare a case for a trial. On the contrary, the commission of optional procedural actions reduced the effectiveness of justice because of the associated costs of the judicial authority. The assistant judge preparing the draft also suffered temporary losses. They should potentially negatively affect other appendix cases. The desired optimally in this case lies in the correct interpretation, namely clarification of the rules of procedural law, which was not found in the case under consideration. This is a careful factor in determining the outcome of effectiveness of justice. A similar situation was observed when the Железнодорожный District Court of Barnaul issued the ruling of the return of the claim. The basis for the commission of such procedural action, according to the court, was the fact that the price of the claim did not exceed 50,000 rubles. This fact would have seemed logically if not the fact that plaintiff, among other things, claimed a compensation for non-pecuniary damage. In this regard, the selected judicial position raises certain doubts, since Part 1 of Article 23 of the Code of Civil Procedure, with the reservation stipulated in Part 2 of Article 23 of the Code of Civil Procedure, the formally executive competence of peace justice, limiting the possibility of considering compensation cases for non-pecuniary damages. As if ignoring these circumstances, the court also refused to exercise the right of judicial protection. And even greater questions in this justice effectiveness, taken into account the fact that plaintiff was advised to turn to the magistrate of the relevant judicial section. The latter clearly interpreting that guide by Article 23 of Code of Civil Procedure of Russian Federation committed the highly anticipated procedural action to return the statement of claim. The plaintiff put themselves in a procedural dead end. The reason for a described situation which reduces the possibility of achieving civil legislation tax to a minimum and increases time and money costs as well as human resources against lies not just in the absence of legal certainty. But the impossibility of ensuring the operation of these regained norms but have been functioning for rather a long period and have seemingly sustainable application practice. One of the factors which influence to unstable application of peremptory norms is the position formed by the Supreme Court of the Russian Federation. So, when considering cases of compensation for moral or physical suffering caused, it must be borne in mind that non-pecuniary damage is recognized by the law as non-pecuniary damage, despite the fact that is compensated in mandatory or as a material form. The court has the right to consider such a claim as independent one, since by virtue of the current legislation, liability for moral damage is not directly dependent on the existence of property damage and can be applied both along with property, liability, and independently. On the other hand, there are others, including those that have found some support among law enforcement positions, however, which have a certain discussion component. So, a statement of claim compensation for non-pecuniary damage is submitted either to a magistrate if simultaneously with the demand of property in the amount of not than 50 hundreds ruble derivatively claim for compensation for moral damage is declared from it. At this stage, it isn't so important to resolve the issues of jurisdiction and analyze all the positive and negative sides of the corresponding conclusion. How important it's to establish common criteria for resolving the issue of the described situation. For the magistrate, after returning the statement of claim, but the district did not be considered that later, in this there is certain interpretation of long exist rule of law. That not compliance with the principle of legal certainty and effectiveness for justice effectiveness. Reasonable questions is whether such a situation has arisen again. Is the tendency natural or is it speech about single errors? The situation indeed is not new, and it's not hardly a matter of simply making mistakes since the above examples are quite common in judicial practice, being just one of the many. The fact is that the justice effectiveness is not only reduced in specific cases, but can be minimized if the current reform of procedural legislation is built on a weak foundation. Unfortunately, such uncertainty launches a complex flywheel of negative social consequences. Subjects are deprived of the opportunity to restore their subjective rights and obtain protection of legitimate interests, which leads to subsequent inter and civil correlation participation. In order to overcome the stage of legal uncertainty and as a result increase the efficiency of legal proceedings, it's necessary to use such legal techniques that do not entail the appearance of casuistic legal norms. Unfortunately, this path is completely unproductive. The actualization process will occur instantly with the development of the procedural flow itself, which will entail only the need for new changes. And in addition, the possibility of a broad system interpretation in this case is objectively reduced. On the contrary, the model of the most general norms can be applied to emerging procedural situations, taking into account the systematic and targeted methods of interpretation. In this approach to building a system of legislation coupled with the subsequent application of norms based on internal conviction and judicial distraction, and that will ensure that unity of judicial practice. The use of general norms does not constitute a violation of subjective rights. The examples considered above indicate the opposite. Even the presence of unambiguous rules of behavior does not entail error-free actions. However, with the ability to ensure variability in behavior, that judiciary makes that most effective use of the basic principles and ideas of civil proceedings. Radeva argues the legal practice can only be effective when the activity is carried out in a certain order, in compliance with the necessary rules and technique. Unfortunately, this is not always the case. The form of activity as a kind of shell cannot predetermine the content. Otherwise, many legal problems would be resolved quite simply. On the contrary, often deviations from their procedural form. In the case where it's not just legal activity but especially judicial, when implementing judicial discretion would make it possible to increase such significant factor as justice effectiveness. There is an opinion that the key categories that form the basis for evaluating the performance of courts should include the purpose, means, and results of this activity. Among the tasks of civil proceedings is called not only the correct and timely consideration and resolution of cases, but the listed tasks are in no case acceptable to consider as optional. In addition to its main function, no matter how paradoxical it sounds, tasks functions become a catalyst that shows how effective justice in these days. Dear guests, thank you for your attention. I hope it was interest for you, and I hope the legal system of the Russian Federation is really interest for you. Maybe we will continue this project, and maybe I can say many interesting cases for you. So thank you that you have seen this video. See you soon. Thank you.